So you're charged with unlawful carrying of a weapon. You are facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. Shh. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge. On February 5th.
If you cannot afford one, one will be appointed to you, sir.
Yes, Judge. On February 5th, 2025, the officer responded to a suspicious person with a weapon on 5900 Gulf Freeway. The officer made contact with the defendant, who was 17 years old. The defendant advised he was inside Jack in a Box while brothers were selling waters outside. The defendant saw a male rushing at his brothers with a knife, pulled out his gun, and pointed it at the male while telling his brothers to run. The officer performed a search on the defendant, locating a 9mm Glock 19, and the defendant advised he bought the gun from a friend for $150.
I mean,
Yes, Judge. In this case, the officer was going off the fact that he performed the search because he indicated there was a firearm. So
he's going to the defense of others.
yes, Judge.
It's another person.
And it's just the way this is pled is because he's underage. He's below the age of 21. That's the way it's pled, Your Honor.
You hear this?
Hold on, I'm gonna go yell at somebody. Hold on. Don't know what's going on. Hi, Judge. Is this young man charged with unlawful carrying of possession for being under 21?
Correct.
Hold on, I've got a kit. Here's the GPS
But I'm
memo.
more concerned about the defense of others. Did you hear it? I mean,
No, hold on.
hold on a second.
Here's GPS.
Let me give you a lawyer, Mr.
Yeah. Oh, I volunteer representation. Yeah,
Give me a record, can you fill that out? please?
I will do that. But here's a GPS memo saying that it's
Hold on a second.
unconstitutional.
You know, Representative gentleman?
Oh, hell yes. Here's the Fifth Circuit saying that it's unconstitutional. Here is the United States District Court, Northern District, saying it's unconstitutional. Here's a motion to quash information. I'll just cross out the name.
Great job.
Yeah, I had to get in this fight yesterday and I'm teed up.
Here you go, Mr. Tito.
Thank you.
Judge.
I was
is there
gonna,
PC?
yeah, look, you gotta be very careful. You know, God forbid something happens where you really dig yourself a hole. I'm gonna find no probable cause, but really, you have to be very careful. You know, sometimes you make a decision in life and it can really have consequences, all right? You know what that means, right? Are you in school? It all starts with school, man. You got to get back into school. This is not a good way to go through life at 17. The more schooling you have, the more money you're going to make.
To change or lift the protective order. This is an alleged incident that happened in August of last year. Since then, he and the complaining witness have been co-parenting. She is here right now. It has been very difficult to co-parent because of this protective order in place that they're trying to abide by. He's having to get hotel rooms so that he can have a place to stay. It's difficult with work. Also, she needs help with the child, and this protective order just has been difficult.
If there's a protective order and they're not supposed to be together and they're here together, that's not a good.
They did not come together.
So I don't know anything about your cases. We're going to do probable cause. You have the right to remain silent. All I know is that you're charged with assault of a family member. You're facing up to a year in jail and or a $4,000 fine. We will do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge. The complainant and the defendant are dating, and on August 23rd, 2024, the officer was dispatched to a family assault, and the complainant stated a verbal altercation began while she was in the car. The complainant exited the vehicle with her child, ran towards the home, and the defendant ran after her. The defendant took the baby and put the baby in the car. The defendant then grabbed the complainant's phone and smashed it to the ground. The complainant stated they got back in the car, and the defendant stated he was trying to drive into a box truck to kill them. The complainant grabbed the wheel to stop the defendant, and he bit her left forearm. The defendant began punching her in the face with a closed fist approximately 2 to 3 times. The defendant then stopped at the gas station, dropped the complainant and the child off, and left. The officer observed the complainant had visible injuries to her left forearm consistent with a bite mark, scratches to her face, and bruising on the left portion of her upper right arm.
Guys, I guess, do you want to go do the rip?
Your Honor, we could reach out to our DVD prosecutor. and see-
CW's here.
Yes, Judge, it's also.
That was-
Yes, Judge. So we would need to reach out to the DVD prosecutor to allow him to perform the writ.
Okay, let's do this. The first thing, I want to know what she says, you know,
Okay,
honor her wishes.
of course,
I don't
Judge.
know what her feelings are.
I spoke with her, Judge, and she is in the position, she does not want to go forward with the charges. She wants Mr. Borrego to be in her child's life. Because of this protective order, it's been extremely difficult to co-parent. I spoke with her. I will let the prosecutor speak with her alone.
Is that his biological child?
Correct, yes.
Okay. Mr. Borrego, take a seat for me in the jury box while we get everything done. And then let me wait for the DVD to get here and then we'll get the rip done and then we'll talk.
Okay, thank you, Judge.
You got the rip?
Yes.
Thanks.
So, I understand that there's some issues in terms of child custody and all that. So what I'm willing to do is agree to no threatening or harassing, but keep the residency restriction because they don't live together. And I don't see a reason to allow him to be back at that residence.
He's currently going to hotels and motels so that he can abide by this protective order. It's been a financial strain on him. He's working, hours have been a little short, so it's just becoming increasingly difficult for him to continue to stay out of the residence, away from his child. So I'm asking that the resident,
My concern is the protection of the
Understood.
complaining witness,
No, Judge,
and
and I will say, I understand that, but given his prior assaultive history, the fact that there's an OR that, allegedly involves another assault after this date, I can't agree to a
I
residency
don't, what are
restriction.
you talking about?
He has 2 TDC trips for ag assaults.
Okay,
Um,
you're saying there's an assault after this assault?
So I have a note that there was some sort of assault involving the same complainant from October. I'm working on getting the offense report to verify
You know
what
what?
I'm
that
not
is.
aware of that, Judge.
So I,
Come up, Mr. Borrego. Come up. I'm not going to allow a contact if there's a prior assault that you're alleging as well now.
Yes, sir.
95% of the people who are in jail now are there because they have no self-control. They get upset, they wig out, and they do whatever the hell they want to do without thinking, if I do this, what's going to happen? If I say this, what's going to happen? The idea that we have these orders in place are so that nothing else happens. The last thing we want is more mayhem and bloodshed on our streets. I mean, every single day we have someone dying on our streets because of no self-control. They're alleging that there's a prior assault with the same complaining witness. I get it. I know that you say no. I get everybody. What do you think? If I had one strand of hair for every person that said that, I'd have a beautiful head of hair. But I'm here to protect every person in this county at all costs. And they're saying you have this assault now. They're alleging so I don't want any contact. I will let you talk to your lawyer. You guys can hash this out. So hold on. I don't want you to talk here. You guys go out there, take your time. There's no rush. We have a lot of time to work things out. But if I have you charged with assault and they're saying that there's a prior one, it's just not going to happen. I get it. You guys talk, but I don't want you to have contact with this person. Don't. If I find that there's a protective order in place, you have to understand that an assault, you pick up a VPO, a violation of protective order, it's one of the worst cases. We can have a hearing to hold you at no bond when you violate condition on these types of cases. You guys go talk, see what you can do about explaining, but all right, please.
So Judge, as of right now, the state wants to we're doing no contact. We're going to leave the protective order as is. Okay.
I mean, it's
Okay. Thank you, Judge.
all right.
Okay.
This isn't absolute, but what I have to know is that you're trying to better yourself. My main concern is that I want you to be a productive person. I want you to work. I want you to work full time because if that's your baby needs food, man. Baby needs clothes. They still eat. The baby needs stuff, My other main concern is that you're alcohol and drug free. And if you can show me that you're productive, that you're working full time, and that there are no issues, we can always revisit it. It's never absolute. But I want to know, look, I don't want to hurt you anymore, but I want you to be the best person you can be. And when you're in that space, that's when you go back, because that's when you're the most helpful. Now, when you're all stressed out and all the shice is here, I don't want something further to happen. That's it. Okay. So look, it's not absolute. Show me that you're a good person. Show me that you're working, you're alcohol, drug free. Come back and we'll talk. All right. Okay. Thanks. The thing is that this is going to continue to happen until you resolve those cases out of state. You have an open case in Tennessee, right?
Georgia.
I know Georgia, but you also got one in Tennessee, in that
Kansas.
Kansas. Both of those cases will haunt you until the day you die, unless you go back and handle those cases. However, it may be all of just hiring a lawyer and reaching out to the courts in Kansas because it's a suspended license case. But it's always going to trail you until you go take care of it. Your lawyer's asking me to set you a bond, and I'm going to, but I have to make it sufficiently high that you realize that we mean business, that you have to go back to Georgia to take care of that case. Do you understand? You also need to understand that I don't play games. If I set you a bond, I'm only going to give you one. I'm not going to do this again. So if you bond out and you fail to go back to Georgia, I will issue a nationwide warrant for your arrest. I'm going to set the bond at 0. And if you don't go back, I set it at 0. I'm going to get you back. And this time I will hold you until Georgia comes and gets you. Do you understand? You have one chance to make this right. So what's the bond amount?
I would ask for $500.
Judge Fletcher, we're asking for a high bond or no bond, 5 figures. That's what Day is requesting.
What kind of bond can you make?
Actually going through cancer treatment right now, so that's the reason I would need to get out, so I can start my treatment.
I don't know that. How do I know that? How do I know you're not just saying that? Regardless, you have to go back to Georgia. So
I didn't know I had this over my head, so.
what kind of bond can you make?
I can pay. I'm gonna be able to pay.
I'm good at 1,000. If you want 1,000, I'll give it to you. But I'm not going to play this game, Mr. Black. So this is an extremely low bond. If you don't go back, it's really not going to end up well for you, especially if you're undergoing treatment for cancer. Because understand that if you don't go back and take care of that business and I have to issue a warrant for your arrest and we get you back, you're probably going to be sitting months in there waiting for Georgia to come get you. You understand? Okay. I'm set about $1,000.
Thank you, Judge. And did you tell?
Yeah, you have 2 weeks from the date of your release to go turn yourself into Georgia. Don't go on a plane because they're going to arrest you. You got to find another way to get up to Georgia, and you have to go turn yourself in. Do you understand? If you don't do that within the 2 weeks, I will issue a warrant for your arrest.
Council, will we set?
Okay, how are you? You look great. When you're clean, you look great. You coherent. The unfortunate thing is that we got to keep you here for that to happen. So you said right now in the felony court that there's nothing, right?
No, I'm gonna check last night, looking for ribs, meds, warrant, blood.
Looks like they just got a lab report yesterday, so they're still getting evidence as of now.
I don't have that, but, and I think that it's gonna take a while to play out, Shreya. And I'm willing to hold as well, because I'd like to see what's gonna happen, because I'm not giving up on you. I'm gonna see where this plays out, and I'd like you to go into treatment as well. I think that's the appropriate thing that is needed in us. And I don't know what it's going to take to get your attention, but hopefully we can somehow before something catastrophic happens, where you end up with a very lengthy prison sentence. So, Shreya, let's just track it. So you're set for the 10th of March. We'll set you for the day after and we'll see what happens.
Judge, after it's.
Of course. Absolutely. All right, Mr. Eli, we'll see you soon. Morning, Mr. Hunt. You're charged. Can you spit the gum out? You're smacking it like a.
Yes, sir.
You were charged with assault of a family member. You were facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you, sir. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge. The complainant is the defendant's mother. On January 3rd, 2024, the officer was dispatched to a family violence call and met with the complainant, who stated that she was discussing a prior incident with the defendant when he became irate and punched the complainant 3 times, causing pain. The officer then spoke with a.
She hit me first.
Just trying to, Mr. Hunt, we're just trying to figure out what's going on. That's it.
And Judge, the officers then spoke with a witness who observed the incident and physically restrained the defendant.
So you have an agreement to do the PTI program, right?
Mental health diversion.
All he has to do is just go get evaluated. Am I right?
Yes, sir.
Mr. Hunt, you've been given a great offer now where all you have to do is get evaluated. If you do that, they're going to dismiss your case.
It's cool. It's not fair, but it's cool.
All they want you to do is speak to someone and they're going to dismiss your case. Is that not fair?
That's fine.
Do we know, have you reached out to the complaining witness to see, is he currently living with complaining witness? Do you know?
Let me see. I'll read the RIP notes, Your Honor. So we don't, I guess we didn't ask whether they live together, but the complainant did tell us that she's fine with no threatening or harassing, as she wants to be in contact with him.
Is he living with mom now?
Okay, sir. Is the complaining witness his mom?
The mother.
Okay, yes, the mom. He is, but she's very involved in getting him his treatment and providing a stable home for him. So
Okay.
we would ask that it would be no threatening or harassing as well.
Mr. Hunt, the only thing I'm going to ask you is please do not have any threatening or harassing contact with your mother. Do you understand, sir?
Yes, Your Honor.
Your Honor, respectfully, we would request that we wait till our DVD prosecutor gets here just to see what his opinions are on what the bond condition could be, and we can email him immediately to get him in here.
Has he done the RIP?
He did the RIP, but we don't know if he has any concerns based on his conversation with her, because we don't know what his impressions were.
And Judge, if he was able, if he doesn't have any contact with his mom, he would have nowhere to go. So
No, I'm saying if there's any further things that he'd like to.
Girl, I want to, this people don't understand. That's why they worry about me, and I got mental health issues, supposedly. And I don't be hearing shit people talk to me, so. Yes, ma'am.
we could talk.
Mr. Hunt, we want to help you. That's all we want to do. No one's here to try to hurt you at all. All we want to do is make sure that nothing happens where you're going to end up going back to jail. That's all we want. So just don't have any weapons, no threatening, harassing with mom, and that's it. So we're going to have you just take a seat real quick. We'll have you sign the conditions and then you guys are good to go. Okay. So I'm not going to reset it yet just to see if they have anything else that they would like to add for now. And then we'll.
See it?
You were charged with driving while intoxicated. It's elevated to a Class A misdemeanor because of the high blow. You are facing up to a year in jail and or a $4,000 fine. You have worked out an agreement where they're offering you 3 days in jail with credit for the 1 day that you've done. You need to understand that by doing this today, this charge will go on your record. It will be there for the rest of your life. From now on, if you pick up any more cases, you will be facing a minimum of 90 days in jail. No more slaps, the proverbial slaps on the wrist. It will go on your record. So if you were pulled over in a car and an officer comes up to you, they smell alcohol, and they see that you have a prior DWI, it's probably not going to go well for you. And if you're not in this country with permission and you do any kind of jail time, get ready because immigration will probably put a detainer on you. Do you understand?
Yes.
What I'm trying to tell you is that even if you have a sip of alcohol, I wouldn't get into a car. You're giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you are not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization under federal law. You give up the right to appeal. Once you plead guilty, it will go on your record. You can never take it off. Is this what you want to do?
Yes.
How do you plead to the offense, guilty or not guilty?
That's
I'm going to find you guilty, sentence you to 3 days in jail, give you credit for the 1 day that you've done. DWI is big business. There is a $3,500 surcharge that normally applies with this type of case that you would be required to pay. We all make mistakes, but the idea is that you don't continue to make decisions that endanger other people. A second DWI is a $6,000 surcharge. If you pick up a second DWI, get ready because you'll probably get took. Do you understand? I will waive it for you now. But if you don't make any right decisions in the future, get ready. Did you say guilty? I did plead to the offense, guilty or not guilty.
guilty.
I will send you to the agreement. Good luck to you, sir. The other case, is this still open upstairs as well, or is
Yes,
this?
but we're hoping to get that resolved based on this plea.
Got it. Do you have an agreement with that? They're going to do?
We have not yet been added to that case. I'm just an associate standing in for Mr. Adams, so I'm not sure what communications they've
Does
had.
Mr. Adams represent him upstairs? Do you know?
I don't think he's been signed on to that case yet, though.
All right, Mr. Henderson, you're charged with terroristic threat. You're facing up to 6 months in jail and or a $2,000 fine. You guys have worked out an agreement where they're offering you 20 days in jail with credit for the 20 days that you've done. You need to understand that this charge will go on your record. It's going to be there for the rest of your life. From now on, you're facing a minimum of 30 days in jail. It's very possible that if you continue with the same course of conduct, that they can use this to enhance you. You could be potentially facing a felony offense if you continue with the same course of conduct. You understand? So it would be very, very careful. You give up a lot of rights by entering into this agreement. You give up the right to a trial, right to compel witnesses to testify on behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. Once you plead guilty, it will go on your record. You can never take it off. You understand? Do you still want to do this? How do you plead to the offense, guilty or not guilty? I'm going to find you guilty. I will follow the agreement. I'm going to roll your court costs so you won't owe anything. Good luck to you, sir.
Thanks.
Ms. Armstrong, you're charged with driving while intoxicated. You're facing, thank you so much, Deanna. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, ma'am.
Yes, Judge. On February 6, 2025, the officer observed a vehicle on Katy Freeway, failing to maintain a single lane and swerving into adjacent lanes. The officer paced the vehicle at 72 miles per hour in a 60 mile per hour zone. And while pacing the officer, the vehicle continued to fail to maintain a single lane and fluctuate between speeds of 68 miles per hour and 74 miles per hour. A traffic stop was then initiated, and the officer made contact with the defendant, observing a strong odor of an alcoholic beverage. The defendant stated she dropped her phone, and that's why she was swerving. And she further stated that she was coming from a bar and admitted to consuming 2 shots of tequila. Standard field sobrieties were conducted, HGN 6 out of 6, walk and turn 3 out of 8, 1 leg stand 2 out of 4. The defendant was read the DIC and considered a breath. The results were 0.145 and 0.156.
And I'm going to find that there's probable cause to go forward with your case. I'm ordering you as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. I'm going to randomly test you. If I find that you're consuming alcohol or illegal drugs, I'm going to revoke your bond, put you in jail. No more PR bonds. Do you understand, ma'am? Can you run the license, see if she has a valid license?
She's eligible, Your Honor.
All right. As long as you have a valid license and liability insurance in your name, you may continue to drive. Just be careful. For now, I'm going to have you go to Victoria, sign a reset. Have you get with Felicia for bond conditions, and then we'll just have you wait. Okay, man?
For Mr. Herrera, we ended up resolving the case this morning through a plea.
What?
We went over, I got the
It
contract.
doesn't matter. It doesn't matter.
Okay.
But you sure this is what you want to do? Okay. Jesse Herrera, come up. So it looks like you guys were going to work out a PTI, but now you just want to plead guilty.
Yeah, yes, sir.
Are you sure?
Yes, sir.
You got to understand that this is a lifetime decision. So don't take it lightly, because once you do this, there's just no turning back. You can't come back next week and it's like Target where you want to return it. There's no buyer's remorse here. Yeah. Okay. If you were 18, it'd be something else, but you're older than 18. So you understand that actions have consequences, right? All right. You're giving up the right to a trial, right to compel witnesses to testify on behalf, confront and cross-examine your accusers, the right to be arraigned, charged, read in open court. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization under federal law. You give up the right to appeal. So once you accept this agreement, it's done. It's over forever. You can never appeal this. Do you understand? How do you plead to the elements of driving while intoxicated? Guilty. I'm going to find you guilty. I'm going to send you to 6 days in jail. I'll give you credit for the 2 days that you've done. You also need to understand one more thing. What we're doing today, from now on, you are facing a minimum of 30 days in jail. The other thing that you need to understand, if you ever get pulled over again, an officer is going to look up your record. If they come to your car and they smell alcohol or dope, they'll see a prior DWI. What do you think is going to happen? Right. So if I were you, even if you have a sip of alcohol, I wouldn't get into a car because it's huge risk. The other thing is that there's a surcharge of around $3,000 that they put on you. On a second, it's $6,000. Everyone makes mistakes. But if you continue to make mistakes that you endanger other people's lives, I'm really going to stick it to you. And it's going to be monetarily and with custody. You get it? I'm going to waive your fees now, but you come back here with the DWI. Get ready. All right.
And he may need bond conditions.
Wow, he made a surety bond on all those cases. Come up, Mr. Portillo. I'm ready to set these for trial. It's 250 days. He's got 5 open cases, and they're very serious. What conditions? Do you know what the felony court?
I have it pulled up.
Okay, Felicia, this is Mr. Portillo.
Yes, Judge. Let me pull them up.
What felony conditions do we have, please? Bless you.
Can't go within 200 feet of the 7015 Foray Road, no contact with Jose Cantu and Teresa Portillo Cantu, broken alcohol testing, travel restricted to remain in Harris County and contiguous counties, no firearms, no.
Do you have a leg monitor on right now?
No, sir.
I'm putting one on you now, and I'm giving you a curfew. I don't want you out in the middle of the night. I don't want you to have any weapons, and I'm gonna have you sign an affidavit with me today, promising me you're not gonna have any weapons. You have with us a disorderly conduct, a discharging a firearm. You have 2 felony assaults, a burglary of habitation, and now you picked up a failure to ID as a fugitive from justice. Your cases are 250 days old, and it's now time to set these for trial. Do you have an offer on these cases?
Oh, look, Your Honor. So
There's not.
there's not, Your Honor.
Counsel, what
I need you to put one on today. It's 250 days.
Counsel, what
Yes,
bond
Judge.
conditions were you referring to? I don't see if there are any bond conditions. And are you looking at the motion for bond conditions or the file bond conditions? Because I currently don't see it.
It's 1875107,
Okay.
order for pretrial.
Yeah, absolutely. Okay. Judge, so you would like to match and add a GPS today?
Yeah, and I want to put a curfew,
Yes, Judge.
7 p.m. to 7 a.m.
He is working in construction from 7 to 5, so.
I'm ready to put these babies to bed. I'm not dealing, it's just way too much drama for me. Mr. Portillo, we have way too many so I'd like you to put an offer today
Yes, Judge.
I want you to speak with your lawyer to see if that's something that you guys, if not, I'm setting your cases for trial today. Do you understand? Take a seat for me, sir.
Judge, would you like to remain in Harris County as well? Yeah.
I have quite a bit of history with Mr. Portillo, not only with the 5 open cases, with other priors that we have had with him. And so let's see, can you put it off on the cases? Let's see what you guys want to do and then come back and just let me know.
Okay.
Please.
Armstrong?
And I just got discovery today on the new one, so
250 days,
well, the
you
new one
just
is,
got
the new one
discovered.
is from December. I mean, there's everybody else. Everybody else.
Okay, I'll give you one reset.
Okay.
I didn't realize that the case is from December. I was looking at the first one where it's from 2023. So
I was appointed December 19th, so I mean, this is really,
okay, I'll give you a setting.
okay.
It's just way too much drama for me and just too much. And it's time for,
He does have, I think, felony on March 12th, so could I do it maybe after that to see, and then if it's done
at that
resolved.
setting, when we come back. I mean, is discovery complete on the failure to ID?
On the Feldo ID? Let me see, Your Honor.
I mean, I just talked about.
Yes, Judge. Discovery is complete on the Feldo ID.
Okay.
It looks like there's just 2 videos that need to be shared to you, and we can share those right now.
I mean, are these it?
Because there's also these 2 that just popped up.
Okay,
So, yeah,
okay.
we'll make sure those are shared too.
Mr. Portillo, come up. This is an affidavit that you're going to swear to me today that you're not going to have any possession of any weapons whatsoever for any reasons. If I find that you have a weapon, I can have a contempt hearing, and every time it's punishable by up to 6 months of jail and a $500 fine. Do you understand? I will do everything in my power to protect my county at all costs. Do you understand? I'm giving you 30 days. It is your responsibility between now and then to meet with Mr. Elek. When you come back, you must either accept the plea bargain agreement or your case will immediately be set for trial. You understand? Come on.